Good morning, Your Honors. Attorney
Joe,
Pat.
give us 1 second until
Sure.
we've all get the clock going. As they say, curb your enthusiasm, but only for
Thank
a
you.
moment. All right, now
Thank you.
you may proceed.
Good morning, Your Honors. Attorney Patrick Mashad for the defendant, Marwan Almele. We're here on appeal, and two primary issues. The first being that there was, the argument is there was no independent evidence to support the co-conspiracy, which allowed the hearsay statements of the alleged co-conspirator. The second is that the defendant's whether or not the defendant's appellate rights were preserved by the trial judge. And in a subset to that issue is the issue of the expert witness's testimony as to the conclusory nature of the alleged drug dealing, if you will. On the first issue on the independent evidence to support, necessary to support the co-conspirators' alleged hearsay statements, I would suggest that there was nothing done by the defendant there was no independent evidence to support anything done by the defendant that he was involved in any kind of co-conspiracy. At best, he walked out into a car after he was summoned by his nephew to come out to where a undercover police officer was located. He came out to the car. He either leaned down or looked down into the vehicle, and there was no exchange of words. There was no exchange of money. And the testimony by the undercover officer supports it that he did not flash any money to the defendant. The defendant did not say anything to him. There is conflicting testimony based upon the suppression transcript in the trial transcript as to whether or not there was ever a handshake. So at best, there may have been a handshake, but even if there were a handshake, the undercover officer testified at trial that he didn't know if the defendant was just shaking his hand to say hello or as a greeting or what his reason for handshake. But again, the defendant would dispute whether there actually was a handshake because at the suppression hearing, there was testimony by that same officer that the defendant did nothing in exchange to this alleged offering of a hand. At that point in time, the other officers that were waiting at the direction of the captain, who was a lieutenant at the time, suddenly approached the defendant and arrested him. So in support of the defendant's position that there was no independent evidence, again, I would say that at most there was a handshake, which I don't believe the evidence supports it was even a handshake. Now, with respect to the appellate rights preserved by the trial judge, during the trial, when there was a motion in limine and there was a lengthy discussion as to the testimony of the expert witness, which was objected to by the trial counsel, the trial judge was clear and explicit that any objections or non-objections would be preserved post-trial, so that the defendant's trial counsel, if he wanted to kind of show the jury that he was objecting for the appearance of objecting, that he could do that. But other than that, any non-objection would be preserved.
As to any aspect of that testimony?
I'm sorry?
As to any aspect of that testimony?
That's the way I read the...
As opposed to just the admissibility of the opinion itself?
Well, I read it as that the trial judge was saying that any objections that might be needed for any reason. So I think it's reasonable for a trial counsel to accept that at its face value.
Well, what was the substance of the motion in limine?
The substance of the motion in limine was primarily the expert's discussion as to the the circumstances involving drug dealing.
Wasn't the defendant's counsel trying not to have the police officer testify as an expert?
He was.
I mean, wasn't that the point of the motion in limine?
That was the primary point, certainly. But again, I go back to the trial judge stated on the record that anything that might be objectionable, if
What
it
did
was.
the judge say here?
I'm sorry?
What did the judge say here?
The judge said.
The defendant said what?
What the judge said was, I will note for the record defendant's objection to the lieutenant serving as an expert witness, and for the reasons stated, plus any other reasons. Just in case something happens at trial, I'll just put on the record, I'll be preserving the defense counsel's objection even during the trial. So we don't get into situations where the appellate court reviews if there's a conviction, which I don't know if there will be, but in the event there is one, change in the standard, heightened standard, because there was no objection. Then he goes on to say, but in any event, something happens and doesn't occur, I'm preserving it for the trial as well, so you don't have to worry about that. I think that gives reliance to the trial counsel that if he doesn't object, that his rights are preserved.
Rights are preserved, though, as to what? I mean, certainly they would be preserved with regard to the issue of the admissibility of that testimony in general, or the admissibility of the expert opinion. Would it be preserved as to objections of leading or objections of the expert going beyond the appropriate opinion of an expert and saying
I would
more than he should have?
I would suggest that would support the reasonable acceptance by a trial counsel that if he doesn't object to anything, that is preserved.
When was this right before the trial started? In other words, it wasn't on a different day? Do you know?
That's a good question. It was the same day, but I believe it must have, I'm not sure if there was an interruption in the trial. I believe it was at the start of the trial, but I could be wrong.
But it went right from this motion to the trial?
Correct.
Okay.
Correct.
But what is the standard? The standard is whether or not the attorney reasonably understood what the judge said to mean that they were preserved. Is that what we are deciding?
Well, I believe the case law supports that. There's a couple cases that support that if the trial judge preserves the rights, that's sufficient with respect to any.
But let's assume we say, no, that's probably not what he meant. Do you still prevail if we determine that the attorney reasonably understood that to be what he meant, even if that's not perhaps what he meant?
I would suggest that it would satisfy that any obligation to object or to sit on that instruction by the judge would satisfy his obligations with respect to objecting or not objecting to that conclusory statement. That leads to the conclusory statement, which the appeals court admitted was a close call. And this, I think, if we accept the trial judge's instructions to the trial counsel that his rights are saved, then it certainly swings in the defendant's favor. But I think even without that, the case law supports that the detective's statements that that this was a drug deal that had gone on is sufficient to overturn the conviction. What I would like to point out is that during his testimony, and this I believe was in the in limine testimony. I take that back. This may have been during the trial. Detective Leto admitted that packaging the drugs that were found would also be consistent as to legal use as well, as his argument. Well, his opinion was that it was an illegal transaction, but he also testified that the packaging of drugs, the way they were packaged, in connection with a proposed trip to Boston that the defendant alleged to be taking, was consistent with legal use as well. Also important with respect to this testimony and with respect to the trial is that there was, the evidence shows that the alleged co-conspirator was not reliable. At no point in time had he proven to be reliable. And so that, coupled with the lack of any independent evidence, I would suggest supports that these convictions should be overturned.
Okay, thank you.
Thank you.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. On the subject of the objection, the Commonwealth's position is that even when a defendant's rights are preserved, I know the appeals court had some opinions on that, but in those situations, it's still, the error that is subsequently considered still has to be something that foreseeably follows from the thing that was originally trying to be objected to, or it essentially removes the relevance of a standard of review. That
What do you do, though, when a judge has gone on and on like this judge has? I mean, this is not, sort of the, okay, it's your objection to the denial of the motion in limine is preserved, period. This judge really made a point of going on and on and on. I mean, there is a trap for the unwary kind of aspect to this, isn't there?
I agree that there might have been hypothetically in the abstract in such a situation, but in this case, I would note that for one, defense counsel did object to the thing that was the same thing that he had been told his rights were specifically preserved on shortly before this testimony came in. He got a 2-page instruction cautioning against prejudicial inferences to the defendant. I think that it's possible to infer from the transcript that he was not essentially led astray by any of the judge's essentially ways of formulating this, that arguably he wanted to be seen to object. He was alert to this. In his voir dire of Detective Leto, he had asked some very long hypothetical questions that were very similar to the ones the Commonwealth asked. It's possible that he was anticipating asking them again. Ultimately, he appears to have decided to just dismiss Detective Leto as a hack, and I think it actually, in his closing argument, argues, this shows how weak their case is. They have to bring in this hired gun who doesn't know anything about the case, just read the police report, and have him tell you that his colleagues had a good case. And the Commonwealth then doesn't even touch on Detective Leto in their closing. So he may have simply shifted strategies and decided that the best idea was to write this guy off, but that letting in that he was planning on building on what the Commonwealth did get in from him.
But I mean, the defense counsel, he does object during the course of it, and he objects when the question is, if you could describe for the jury, if an individual is arrested with plastic baggies of 2 Suboxone tabs, 30 Klonopin, as well as 20 Percocets, along with $416 in his person, what significance would that have for you? Isn't it fair to say that that objection indicated that the defense counsel was objecting to him making some assertion based on these facts and this defendant? Isn't that precisely the claim here, that he basically was talking about this defendant on these facts?
Well, he ultimately did, but I would argue that the hypothetical question was the most proper formulation of that was heard, that essentially that the problem arose not with that question, but after that question. And that
By
so
the
it's-
answer,
Excuse me?
from the answer.
Yes, Your Honor. And that, so objecting to the question, he obviously didn't want this testimony to go there, but that was not actually, that that question was not problematic, and it was properly denied, and it was not necessarily anticipated that it would lead to the closer approaches to the ultimate issue that ultimately occurred.
So your position is that it is okay for a prosecutor to ask, let's just take a hypothetical here, and then set forth all of the facts that the prosecutor has shown about this particular case.
My understanding was that was the approved manner of doing it, Your Honor. Obviously,
Okay, so your view is that's okay, but when you go then to take the next step and says that this defendant, drugs here were intended for distribution, that crosses the line.
I think that my reading of the cases has been that the line is considered to be at the point where, and it's true that this can get into potentially hair splitting, and the cases have addressed that, but that the ultimate question is the witness talking about a hypothetical person who's in a situation like the defendant, or are they tying it to the defendant? And I agree that necessarily leads to an issue that continues to be discussed in the case law, but that is in fact where the line has been drawn. And I mean, there's been discussion about how it doesn't come down to whether they use the formulation consistent with or not, because that really does get technical. But there's been discussion about, was the person a percipient witness? Do they know anything about the case? Would the jury think that they really had knowledge of the case? Is the basis of their opinion discussed? If they just say, I think he's obviously, in my opinion, he's guilty. I mean, first, obviously that would be over the line for a number of reasons, but does the expert explain the basis of the opinion being rendered such that the jury can sort of look under the hood and decide whether they think that what they think of this, or is the expert essentially just vouching and, I'm a police officer and I think this, therefore you should think this too, would be at least the defense interpretation. And so it's traditionally, the hypotheticals have been very, very closely viewed to the facts of the case. And that is the law as it has been, I would argue.
Does it make a difference what the standard of review here was?
I don't think it's dispositive. Obviously, the difference between substantial risk and prejudicial error always sort of affects analysis. But I think that in this case, the evidence was reasonably strong. I would argue you could actually infer that defense counsel very effectively dispensed with Detective Leto's opinion about as something that was likely to weigh very heavily with the jury. Again, the Commonwealth didn't go there in closing, whereas defense counsel did. There was the evidence, again, once you get in Ahmad's statements, you have somebody who says, my uncle's going to sell you drugs, his Percocets, he's got this many. He gives other details of, he gets 180 a month, he sells them for this much, I can get you a better deal later, and essentially brings the undercover officer to his uncle, who comes out, leans into the car. There's evidence that he sticks his hand in the car with money visible, with Ahmad having been shown the money. And then when they search the defendant, he has the expected number of Percocets on him, in addition to $400, which could be found. Ahmad had said that his uncle had sold previously 100 Percocets for $400, which is why he only had, I believe, 20 left. And the defendant leads them to his prescription bottle, which has been filled with 180 Percocets 6 days earlier and is now empty. He does not offer any explanation for where the other Percocets are. And additionally, this is a case where the jury did not convict on every charge, and they asked a jury question, which was that they wanted to see Detective Oliveira's testimony again, which they couldn't get because there wasn't a copy, but would seem to suggest that whatever was interesting the most, it was not in the expert testimony, and the expert testimony did not reassure them on whatever point that they were continuing to discuss. They did not take it as an imprimatur of sufficiency of the evidence in this case, and that they still had many other things to talk about. They reached a split verdict. And under the circumstances, I think that it is reasonable to conclude that under either standard, this jury on this evidence was not affected. And they also heard they heard several lengthy instructions on how to apply that evidence. The judge spoke in very accessible, sort of colloquial language about, this is just some guy. It doesn't matter that he's an expert. You don't have to take his word for it. You have to find the underlying facts, and both at the time of the testimony and afterwards. And in light of all of that, I would say that this case survives either standard of review.
Thank you.
Thank you, Your Honor.